Good morning, everyone. This is Dr. Claire Broughton, and today I'll be discussing with you Chapter 3 on the criminal law and daily practice. Let me share my screen first. So today, as I mentioned, we'll be talking about criminal law and daily practice. So first, when you think about criminal law, the very first practitioner that comes to mind is obviously police officer. According to Devon Peck versus Alford, an arresting officer does not need to know precisely what crime was committed at the time of arrest. Okay, so if you're a police officer, then you can arrest someone on the basis of probable cause. And even if someone reports it to you and just calls it in, the only exception would be for misdemeanor. A police officer cannot make an arrest for misdemeanor offenses unless he personally observed the misdemeanor happening in front of him. The only exception would be breaches of the peace, wherein someone can call in, whether it's a police station or someone can report to a police officer that there's a breach of peace occurring somewhere. And even if the police officer did not personally observe the breach of peace, then the police officer can still make an arrest. Okay, so look at this example. Paul sees Peter jaywalking. Paul informs Dan, a peace officer, that Peter jaywalked. Dan catches up with Peter and arrests him. Was the arrest legal? In this case, jaywalking is a misdemeanor offense. Since Dan, the peace officer, did not personally witness Peter jaywalking, Dan cannot make an arrest because, as I mentioned, for misdemeanor offenses, the police officer must have personally observed the misdemeanor. Now, what is the process of filing charges? There would be district attorneys or county attorneys. In large counties, the district attorney files charges for felonies and state-level misdemeanors. The county attorney only handles civil matters. In Texas, the Texas Attorney General has no prosecutorial authority, but can only assist local prosecutors, whether they're prosecuting hate crimes, computer crimes, telecommunications crimes, money laundering, or insurance fraud. So how does the process of filing charges start? It starts with the filing of a sworn complaint. So what is direct filing? Direct filing is when the peace officer or police officer files directly the charge for petty offenses, traffic violations, and disorderly conduct and shoplifting. For felony cases, there has to be a grand jury indictment, meaning that there has to be a grand jury investigation who issues an indictment on whether or not the offender should be charged with a specific felony. For misdemeanor offenses, it's the prosecutor who files the information containing the charges. So this is an illustration of the Texas court system for criminal cases. As you will see, for class scheme and misdemeanor and city ordinances from the Justice Court and Municipal Court, it can be appealed to the county court. And from the county court, it can be appealed to the Court of Appeals, and finally to the Court of Criminal Appeals. The district court, in cases of felony decisions, the offender can appeal the case to the Court of Appeals. And again, it's discretionary for the Court of Criminal Appeals on whether or not to accept appeals from the Court of Appeals. Now, the only exception is for death penalty cases that are decided by the district court, where the district court handles a judgment of death penalty for a felony offense. This can be directly appealed to the Court of Criminal Appeals without going through the Court of Appeals. Again, this is the slide for the U.S. Supreme Court. Okay, you will see that state Supreme Courts, you will see a corresponding federal system and a state Supreme Court system. On the right side, any decision going through the state courts, once it reaches the state Supreme Court, can be appealed to the US Supreme Court. And then in the federal system, any case that goes through the federal courts can be appealed to the US Supreme Court. Now, the question is, what are the burdens of proof? What are the problems of proof? If you're presenting a case in court, what type of evidence should you do you need to present, and what type of proof is needed to be able to secure a conviction? For criminal cases, it's proof beyond reasonable doubt, okay? So before we know what beyond reasonable doubt is, you need to know what reasonable doubt is. Reasonable doubt is doubt based on reason and common sense. So it's that kind of doubt that would make a reasonable person to hesitate. So it means that if it's beyond reasonable doubt, then it's evidence or proof of convincing character that would make one rely and act without hesitation. Now, this is a concept you need to learn. It's corpus delicti rule. Literally translated from Latin, corpus delicti means body of crime. It requires evidence independent of the suspect's confession. There are two elements, injury or loss, and the criminal act as cause thereof. Does Texas follow the corpus delicti rule? Yes, Texas does. So there has to be evidence independent of the suspect's confession. Now, what does statute of limitations mean? Let's consider this case. You leave class one day and discover that your prized sports car has been stolen from the parking lot in front of CJ Building, Criminal Justice Building. You notify the police, who take the report and enter the vehicle's descriptive information into the national database for stolen cars. You call your insurance agent and report the loss. The insurance company pays the full market price of your car. A decade later, you are notified by police that the suspect, Dan, stole the vehicle and drove it to Canada. Can Dan be prosecuted for theft? You will know that under the Texas statute of limitations, okay, theft has a 5-year statute of limitations. So look at the slide, 5 years for theft. This means that the crime of theft must be prosecuted within 5 years from the date it's actually discovered or committed. So in this case, your car was stolen one day, and it's a decade later, 10 years later, okay, that the police are aware that the suspect stole the vehicle and drove it to Canada. So you would probably think, okay, 10 years is more than the prescribed 5-year statute of limitations. Since the case was not filed within 5 years from the time it was committed, then the statute of limitations has prescribed, and Dan can no longer be prosecuted for theft. However, okay, and this is an important concept, for the purpose of statute of limitations, it is suspended when the offender is out of the country, out of the jurisdiction of the state that has jurisdiction over the criminal case. So here, since Dan drove it to Canada, then the statute of limitations has told, or is suspended while he was away, and it starts again when he came back. So he can be prosecuted for theft, but it would be discretionary on the prosecutor, on whether or not it's worthwhile to prosecute him, considering that evidence may have, lapsed already, and it would be difficult to prove. What you need to know for the Texas statute of limitations is that for murder and manslaughter and several types of sexual assault, and then failure to stop and render aid where death results, there is no limitation, meaning these offenses can be prosecuted anytime. So what does tolling of statute of limitations mean? In the example I gave above about the sports car that was stolen, and then the offender drove it to Canada, the statute of limitations is tolled, and it means that it is suspended. It's like it's stopped, okay? So it does not run until the offender comes back to the state that has jurisdiction over the criminal offense. When is it stopped? It is stopped upon the filing of formal charges in court. Why is this relevant in criminal procedure? Well, it's relevant because offenders must be prosecuted within the specific time frame prescribed by the statute of limitations. So this means that if the statute of limitations has prescribed, the offender can no longer be prosecuted, with the exception, obviously, of tolling of statute of limitations. So if the offender fled the jurisdiction of the court or of the state, then he can still be prosecuted once he comes back. What is double jeopardy? Double jeopardy is based on the Eighth Amendment clause that prescribes that no person shall be subject uh, for the same offense, okay? And there are three possible situations: a second prosecution for the same offense after he was acquitted, a second prosecution for the same offense after a conviction, and multiple punishments for the same offense. Let's look at this case illustrates double jeopardy. Lex, a previously convicted felon, is in need of quick cash. Armed with a pistol, Lex enters the First National Bank of Smallville and demands money. The frightened bank teller gives him $5,000. Lex flees only to be apprehended by police a short time later. Lex is charged with aggravated robbery, felony, theft, and unlawful possession of firearm. He is convicted of all three offenses. On appeal, he argues that the convictions violated the double jeopardy clause. He would be right, okay? Because here, felony theft is a lesser offense. It is already included in the crime of aggravated robbery. So since it's a lesser offense included in the crime of robbery or aggravated robbery, Lex cannot be charged with both offenses. Robbery, if you will look at your Texas Penal Code, is simply theft plus assault. So it's a combination of these two crimes. And since robbery is a combination of theft or assault, once you're convicted of robbery, you can no longer be convicted of theft or assault, which is included in the same offense. And this is actually what you call the Blockberger test from the Blockberger versus United States case decided by the Supreme Court in 1932. So the Blockberger test states that there is no violation of double jeopardy clause if each crime requires proof of an additional element that the other does not. Okay, lesser included offenses are merged into the bigger offense. For example, theft and burglary. Let's say someone breaks into a residence and breaks and enters and commits theft inside. Once the person is convicted of burglary, the person can no longer be convicted of theft because theft is an included offense in the crime of burglary. Now let's look at this. Is conviction under different laws, both state law and federal law, prohibited by the double jeopardy clause? No, because these are separate sovereigns. The state is a separate sovereign from the federal government. What does dual sovereign doctrine mean? Precisely as I explained above. Let's look at this case. Dan steals Paul's car in Texas and drives it into Georgia. Under what laws can he be prosecuted? He can be prosecuted in Texas and Georgia. So what does lesser included offense mean? Lesser included offense means that it is an element of a bigger offense. As I mentioned, theft is a lesser included offense in burglary. Theft is also an included offense in robbery. What is the merger doctrine? Merger doctrine means that lesser included offenses are merged into the bigger offenses. So you cannot charge or convict an offender of a lesser included offense. Why is it important to know these doctrine? For plea bargaining purposes, okay, usually a prosecutor would charge the most serious crime so that if the evidence is not sufficient, the offender can be convicted or can plea bargain to a lesser offense. Again, and also for double jeopardy purposes, once you're convicted of one offense, you cannot be convicted of an offense that is included in the bigger offense or is an element of the bigger offense. What are issues in sentencing? In Texas, the defendant has the option of jury sentencing. Okay, and because of the bifurcated trial, a jury can impose a sentence, can determine guilt or innocence, and then the jury can also determine the appropriate sentence of the offender. Now let's look at hate and bias crimes in Texas. Under Texas law, if a person or property was intentionally selected because of the defendant's bias or prejudice against a group identified by race, color, disability, religion, national origin or ancestry, age, gender, or sexual preference, it would be a hate crime. So, what does it mean exactly? It means that the person would be convicted of the crime that he committed, but because it's motivated by hate or bias, the penalty is increased to the penalty for the next highest category of offense. For example, for Class A misdemeanors, the penalty would be increased to a minimum of 180 days in jail, and would not be increased to a minimum of 180 days in jail. And first-degree felony murder, it would not be increased to capital murder. These would be the only exceptions to the sentencing for hate or bias crimes. Now let's look at this case. Dan and Dennis are members of a neo-fascist group that believes that heterosexual whites of European descent are the superior race. While driving around one evening, they observe Paul exiting a local bar that is known to cater to homosexuals. Assuming Paul to be a homosexual, they follow him and assault him in a parking lot. Police officers arrive at the scene and arrest Dan and Dennis. Investigation shows that Paul is not a homosexual, but went to the bar to sell a sound system. Have Dan and Dennis committed a hate crime? Yes. So it doesn't matter that the person that they believed was a member of a protected group wasn't actually a protected group. If they were motivated by bias against that protected group, then it would be a hate crime. Okay, thank you for listening. And I hope that you learned a lot from this lesson, and have a good day, everyone.